Marianne Bachmeier. On May 5, 1980, in Lübeck, Germany, a mother's world shattered. Her daughter Anna had skipped school that day and ended up at the home of Klaus Grabowski, a 35-year-old butcher. Grabowski was no stranger to law enforcement. He had been convicted before for similar offenses and had even undergone surgical castration as part of his earlier sentence. But Grabowski had been receiving hormone treatments that allegedly restored what the surgery had taken away. Anna was found deceased. Her body had been hidden in a cardboard box beside a canal. She had been strangled with pantyhose. Grabowski confessed after his fiancée reported him to authorities, but what he said during his trial would ignite something far beyond legal proceedings. During the trial that began in early 1981, Grabowski made claims that enraged Marianne Bachmeier. He said Anna had tried to blackmail him with false accusations. He painted himself as the victim. For Marianne, sitting in that courtroom day after day, listening to these statements about her daughter, something inside her broke. On March 6, 1981, the third day of Grabowski's trial at Lübeck District Court, Marianne arrived with more than just grief. She had smuggled a .22 caliber Beretta pistol into the courtroom. Security was different back then. Metal detectors were not standard in German courtrooms. As proceedings continued, she stood up from her seat. She raised the weapon and fired 8 shots at Grabowski from behind. 7 bullets found their target. Out of the 8 shots fired from the Beretta, 7 struck Klaus Grabowski, primarily in the back. Witnesses heard her words as guards rushed toward her. She said, "He killed my daughter. I wanted to shoot him in the face, but I shot him in the back. I hope he's dead," and called him a pig. She surrendered immediately. There was no attempt to flee. The act had been done in full view of judges, lawyers, and spectators. The courtroom had become a crime scene. How had she smuggled the weapon inside? The pistol had been hidden in her purse. She had planned this. She had acquired the firearm. She had brought it to court. This was not a spontaneous decision. Marianne's trial stretched across 28 days in 1983. Prosecutors initially charged her with homicide, but after evidence of her profound grief and the inflammatory nature of Grabowski's courtroom claims emerged, the charges were reduced. Under German law, she was convicted of intentional killing and unlawful possession of a firearm. While often translated as manslaughter in English-speaking media, the German court specifically noted the intent behind the act, while providing a lenient sentence due to the mitigating circumstances of her grief. Her sentence was 6 years in prison. She served 3 before being released on probation. Public reaction across Germany was extraordinary. Opinion surveys show that many Germans believed the sentence was either fair or too harsh. Some saw her as a grieving mother, pushed beyond her breaking point by a system that had failed to protect Anna. Others worried about the precedent of taking the law into one's own hands inside a courtroom. Marianne sold her story to Stern magazine for approximately $158,000 to help cover her mounting legal costs and expenses. But did she regret what she did? In a 1995 television interview, Marianne stated clearly, "I shot him after careful consideration to enforce the law on him and to prevent him from further spreading lies about Anna." The words "careful consideration" were key. This was not an act of temporary insanity. During a psychiatric evaluation, she had written a handwriting sample that read, "I did it for you, Anna." Surrounded by 7 hearts, Marianne Bachmeier died of pancreatic cancer in 1996 at the age of 46. She was buried alongside her daughter Anna. In death, mother and daughter were reunited. The case continues to spark debate decades later about taking the law into one's own hands, the limits of the legal system, and what happens when a parent believes the courts have failed their family. Her story has been referenced in legal discussions, documentaries, and debates about courtroom security and vigilante justice. The next case would cross international borders and span nearly 3 decades. Andrzej Bomberski. On July 9, 1982, 14-year-old Kalinka Bamberski died at the home of her stepfather in Germany. Dieter Krombach was a cardiologist, a man of medicine and supposed healing. He told authorities that he had given Kalinka an injection of cobalt ferricid, claiming it was either for tanning purposes or to treat anemia. He said he also gave her a sleeping pill. The next morning, she was found deceased in her bed. Kalinka's father, Andrei Bamberski, lived in France and had been divorced from her mother for years. When he learned of his daughter's passing, something about the explanation did not sit right with him. A healthy teenager does not simply die overnight from a tanning injection. Autopsies revealed disturbing details that supported his suspicions. There were injection marks on Kalinka's body in places that did not align with a simple medical procedure. Medical examiners found a vaginal tear, evidence that pointed towards something far more sinister than Krombach's story suggested. They discovered aspirated stomach contents, suggesting she had inhaled vomit while unconscious, unable to protect her own airway. There was also a whitish substance present that was never tested. While initial German investigations were criticized for not testing the substance found in Kalinka's body, subsequent forensic reviews in the French courts analyzed the reports and concluded the substance was likely semen, supporting the theory of a drugged assault prior to death. German authorities closed the case without filing charges. Despite expert medical opinions stating that the injection Krombach administered had likely caused her passing, no prosecution moved forward in Germany. For Andrei Bamberski, this was unacceptable. His daughter deserved justice. He began a relentless campaign that would consume the next 27 years of his life. He distributed leaflets in Krombach's neighborhood, accusing the doctor of taking his daughter's life. The leaflets detailed the autopsy findings. They questioned why a cardiologist would inject a teenager with an iron supplement meant for treating anemia when she showed no signs of the condition. Krombach sued him for defamation. Bamberski lost the lawsuit and was ordered to stop his leaflet campaign. But he did not stop fighting. He hired lawyers in both France and Germany. He pushed for trials. He spent his life savings pursuing Krombach across two countries' legal systems. He became obsessed with forcing Krombach to face consequences. Could a father's grief outlast the bureaucracy of two nations? In 1995, France tried Krombach in absentia. French authorities had jurisdiction because Kalinka was a French citizen. He was convicted and sentenced to 15 years for causing unintentional death. But Krombach never served a day. In 2001, the European Court of Human Rights annulled the conviction due to procedural flaws related to trials in absentia. Krombach remained free in Germany, protected by laws that prevented extradition for the same offense he had already been tried for in France. By 2009, 27 years after Kalinka's passing, Bamberski feared time was running out. The statute of limitations was approaching. Legal avenues were exhausted. He made a decision that would finally force the issue and bring Krombach onto French soil. Bamberski paid 19,000 euros to have Krombach abducted from Germany. He hired 3 men to carry out the operation. They beat Krombach during the abduction, fracturing his skull in the process. They drove him across the border to Mulhouse, France. They chained him near a police station and left him there for authorities to find. Bamberski was arrested nearby with the payment money still in his possession. He was released on bail shortly after. The plan had worked. Krombach was now on French soil. Now in French jurisdiction, Krombach could finally face trial properly. In 2011, he was retried and convicted under French law. He received a 15-year sentence. The conviction was upheld on appeal in 2014. For his role in orchestrating the kidnapping, Bamberski received a 1-year suspended sentence in 2014. He would not see the inside of a prison cell. He confessed to orchestrating the abduction. His motivation was simple and unwavering. Justice had been delayed for too long. Though no direct quotes from Bamberski about the kidnapping operation have been widely published, his actions across nearly 3 decades spoke clearly. He pursued Krombach relentlessly for 27 years. never wavering in his belief that the doctor had drugged Kalinka. Dieter Krombach was released from a French prison in 2020 on medical grounds and died on September 12, 2020, in a nursing home in Germany. Bamberski continues to live in France. The case exposed the complications of cross-border justice within the European Union and demonstrated how far one parent was willing to go when two countries' legal systems could not align to deliver what he viewed as justice for his daughter. Some cases happen in an instant, captured on camera for the world to see. Gary Plauché. Jeffrey Doucet was a karate instructor in Baton Rouge, Louisiana. For over a year, he groomed and harmed Jody Plauché. Doucet built trust with the Plauché family through his position as an instructor. He positioned himself as a mentor figure, someone the family could rely on. Behind that facade, he was committing terrible acts against their son. On February 19, 1984, Doucet abducted Jody, taking him across state lines to California. This was a federal offense. For days, he held the boy in a motel room in Anaheim. The harm continued during this time. Jody managed to make a phone call home. His parents were frantic. Police traced the call to California. On February 29th, authorities arrested Doucet at the motel and took him into custody. Jody's father, Gary Plauché, learned his son was safe, but that the nightmare was far from over. Doucet would be extradited back to Louisiana to face charges. The date was set, March 16, 1984. Doucet would arrive at Baton Rouge Metropolitan Airport under police escort to be formally arraigned. Gary Plauché was waiting for him at the airport. He had disguised himself with a hat and sunglasses to avoid being recognized. He positioned himself strategically near a bank of payphones in the airport terminal. His friend, a local television cameraman, may have tipped him off about the exact time and location of Doucet's arrival, though this was never proven. As officers walked Doucet through the terminal, television news cameras were rolling, capturing footage for the evening news broadcast. They had no idea they were about to film something far more dramatic than a routine extradition. Plauché stepped forward from his position. He raised a .38 revolver. He fired one shot directly into Doucet's head at point-blank range. The crack of the gunshot echoed through the terminal. The entire event was broadcast on live television. Doucet collapsed to the floor. He died the next day from his injuries. Officers immediately wrestled Plauché to the ground and arrested him. He told them, "If somebody did it to your kid, you'd do it too." Those words became the rallying cry for his supporters. The case sparked intense public debate across Louisiana and beyond. Prosecutors charged Plauché with second-degree homicide, which carried a potential life sentence. But the community response was overwhelming and immediate. Many locals called him a hero. They organized fundraisers to support his legal defense. Letters poured into the district attorney's office. The question became, should a father face the full weight of the law for taking down his son's tormentor? What would the courts decide? Psychiatric evaluations became crucial to the case. Experts evaluated Plauché extensively. They found that he had been in a temporarily psychotic state when he pulled the trigger. His lawyers argued he had not been in full control of his actions due to extreme emotional disturbance caused by learning what Doucet had done to Jody. The psychiatric defense was supported by testimony about his mental state in the days leading up to the shooting. Plauché pleaded no contest to manslaughter, a reduced charge from second-degree homicide. The judge handed down a sentence that shocked many legal observers. 7 years in prison, fully suspended. He received 5 years of probation and 300 hours of community service. He never spent a single day behind bars for taking another person's life on camera in front of police officers. Did the punishment fit the circumstance? Or did the circumstance change the punishment? Public support remained strong throughout the proceedings and after. The local community saw him as someone who had done what any father would want to do: Jody Plauché, as an adult, struggled with complex feelings about his father's actions. He wrote a book titled Why, Gary, Why?, to share his perspective on what his father did and how it now affected the rest of his life. The title itself captured the ambiguity he felt. Gary Plauché died in 2014, never expressing regret for his actions. In interviews over the years, he maintained that he would do it again if faced with the same circumstances. The case continues to be cited in legal discussions about parental rights, temporary insanity defenses, and whether there are moments when society makes exceptions to the law based on emotional circumstances. The video footage of that airport shooting remains one of the most widely circulated examples of a parent taking the law into their own hands. It has been viewed millions of times online and continues to generate debate about justice, revenge, and the limits of parental protection. But what happens when that moment occurs, not in an airport, but in a courtroom? Ellie Nessler. Daniel Driver was a camp counselor in California with prior convictions on his record. The convictions should have prevented him from working with young people. But somehow he had slipped through the system. In 1988, he was accused of harming 5 boys during a camping trip, including William Nessler. The allegations were serious and detailed. Each boy had come forward with similar accounts. A preliminary hearing was scheduled for April 2, 1993, at the Tuolumne County Superior Court in Jamestown. Ellie Nessler, William's mother, attended the hearing. She had been struggling with substance use, specifically methamphetamine, which would later become a significant factor in her defense strategy. As Driver sat in the courtroom, awaiting the proceedings, Ellie reached into her purse. She pulled out a handgun she had brought with her. She fired 5 shots into Driver's head, ending his life instantly in front of the court. The courtroom erupted in chaos. Bailiffs rushed forward. Ellie was immediately restrained and arrested. There was no question about who had done it, how it happened, or why. The entire courtroom had witnessed it. Her trial became a national spectacle that divided public opinion sharply. Prosecutors charged her with homicide. They argued this was premeditated. She had brought a weapon to court. She had fired multiple times. This was not self-defense. Her defense team argued that she had been driven by a combination of maternal instinct to protect her son and impairment from the substances in her system. They painted a picture of a woman pushed beyond reason by what Driver had done to William. The jury convicted Ellie of voluntary manslaughter, not the more serious charge of murder. She was sentenced to 10 years in prison in 1993. She began serving her sentence. She served 3 years before her conviction was overturned in 1996 due to evidence of jury misconduct that came to light. Her conviction was overturned because a juror, Laureen Tolkes, failed to disclose that she had been a victim of a similar crime and had actually discussed the case with co-workers during the trial, expressing a belief in Nessler's guilt before the verdict. Would she walk free? During the retrial proceedings, Ellie's legal situation became more complicated. She was arrested again for possession of methamphetamine and illegal firearms while out on bail awaiting her new trial. This undermined her defense significantly. The prosecution argued that her continued substance use showed a pattern of behavior and poor judgment rather than a one-time emotional breakdown. This time, she accepted a plea deal to avoid a potentially harsher sentence. She pleaded guilty to voluntary manslaughter and Driver's passing, and received a sentence of 6 years to be served alongside her other charges. Public opinion remained divided throughout both trials. Some viewed Ellie as a protective mother who had snapped under unbearable pressure after learning what Driver had done to her son. They saw her as someone who had taken action when the legal system was moving too slowly. Others saw her as someone who had taken the law into her own hands while under the influence of illegal substances, making her actions less defensible. A juror from her first trial reportedly said, "It was an execution." That statement captured the prosecution's view of what had happened in that courtroom. Ellie Nessler was released from prison in 2003 after serving her reduced sentence. But her health had been declining for years. She was diagnosed with breast cancer, and the condition worsened over the following years despite treatment. She died in December 2008 at the age of 56. Her son William survived her, having lived with the knowledge that his mother had taken a life in his name. Her case remains one of the most controversial examples of parental retribution in American legal history. It raised difficult questions about the role of substance use in temporary insanity defenses, the influence of public sympathy on jury decisions, and whether a mother's protective instinct can ever legally justify taking a life in a courtroom. The fact that she had been using methamphetamine complicated the narrative of a grieving mother acting out of pure maternal instinct. It introduced questions about judgment and premeditation that continue to be debated. The next case would involve not one parent, but two. Barry Gilton and Lupe Mercado. In San Francisco's Western Addition neighborhood, Barry Gilton and Lupe Mercado were parents trying to protect their daughter from the life she had been pulled into. Their daughter had become involved with Raymond Brooks, a man they believed was exploiting her and profiting from her situation. Brooks had a history with gang activity and was a known associate of the Western Addition CDP gang, one of the most active criminal organizations in the area. The Western Addition had long struggled with gang presence. The CDP gang controlled territory and engaged in various criminal enterprises. Brooks was entangled in this world, and Gilton and Mercado saw their daughter spiraling deeper into it. They believed Brooks was the cause of her downward trajectory. They felt the authorities were not doing enough to separate him from her or to intervene in what they saw as exploitation. They decided to take matters into their own hands. On an undisclosed date, Gilton and Mercado carried out a plan they had developed. They located Brooks in the Western Addition neighborhood. Gilton was the shooter. He fired multiple shots from a vehicle in a drive-by style attack. Brooks was hit several times and died from his injuries at the scene. Ballistics analysis later matched the weapon used to the casings found at the scene, providing forensic evidence linking the shooting to Gilton. The investigation into Brooks' passing was initially complicated by the gang connections. Authorities were focused on rival gang activity as the likely motive. Drive-by shootings were not uncommon in territory disputes. But as investigators dug deeper into Brooks' personal life and associations, evidence began pointing in a different direction toward Gilton and Mercado. Witnesses came forward. Some had seen the vehicle. Others had heard Gilton and Mercado talking about Brooks in the days before the shooting. Phone records were examined and showed contact between the two parents in the hours leading up to the incident. The picture became clearer. Both parents were arrested and charged. The prosecution argued that this was premeditated. They had not acted in the heat of the moment. They had planned the act over time. They had acquired the weapon. They had tracked Brooks' movements and patterns. They had chosen a time and place. This was not a crime of passion, but a calculated decision to eliminate someone they saw as a threat to their daughter. During the trial, Gilton was convicted of RICO conspiracy due to his own gang associations, separate from the Brooks situation. But the jury made a surprising decision regarding the charge specifically related to Brooks' passing. After years of deadlocked juries and legal delays, Barry Gilton was convicted of first-degree murder in April 2024 for the 2012 shooting of Raymond Brooks. As of 2026, he is serving a sentence of 50 years to life in prison. Mercado's role was viewed differently by the prosecution. She had been involved in the planning stages and had knowledge of what was going to happen. She had not pulled the trigger herself, but she had participated in preparing for the act. She faced charges as an accessory to the shooting. The prosecution argued she was equally culpable because she had helped plan it and had not stopped it or reported it to authorities. The defense argued desperation for both defendants. They painted a picture of parents who felt they had no other options to protect their daughter. Their daughter was in danger. They had tried going through proper channels. They had reported concerns to authorities. Nothing had worked effectively or quickly enough. They felt abandoned by the system that was supposed to protect their family from people like Brooks. The jury was not entirely unsympathetic to their plight, as evidenced by the acquittal on the direct charge. But the law is clear about taking lives outside of immediate self-defense situations. Gilton faced a sentence with a maximum of life in prison for the conspiracy charges. Mercado received a sentence of up to 15 years for her role as an accessory. The case highlighted the intersection of parental protection, gang influence in urban communities, and the desperation that can drive people to irreversible decisions. It raised difficult questions about how parents should respond when they believe their children are being exploited, and the authorities are not intervening effectively or quickly enough to make a difference. Gilton remains imprisoned, serving his sentence. The family's story became a cautionary tale about the limits of parental intervention and the legal consequences that follow vigilante actions, even when motivated by protective instincts. Sometimes the passage of time does not diminish the desire for retribution. Jay Maynor. In Cullman, Alabama, Julia Maynor had endured years of harm at the hands of Raymond Brooks. Yes, the same name as in the previous case, but a different person entirely in a different state. This Raymond Brooks had tormented Julia for years during her childhood. The harm had left deep scars that affected every aspect of her life. She struggled with relationships. She struggled with trust. She struggled with the simple act of feeling safe in the world. Jay Maynor was Julia's father. He watched his daughter struggle with the aftermath of what Brooks had done to her. He saw her pain manifest in ways both visible and invisible. He watched her try to rebuild her life piece by piece. But knowing that Brooks was still out there, living freely, going about his days without consequence, ate at him constantly. For years, Jay carried that anger deep inside. He maintained contact with Julia. He supported her as best he could through her recovery and therapy. But the thought of Brooks, walking around without facing real justice for what he had done, never left his mind. It consumed him. It followed him through his days and haunted his nights. On June 23, 2014, Jay Maynor made a decision that had been building for years. He located Raymond Brooks. He confronted him. He brought a firearm. He shot Brooks, ending his life. The years of rage and grief had culminated in those final moments. Jay was arrested shortly after the shooting. The evidence was overwhelming and straightforward. Ballistics matched the weapon to the scene. There were witnesses who placed Jay near the location at the time of the shooting. Security cameras had captured his vehicle in the area. He did not deny what he had done when questioned by police. He had reached his breaking point. During his trial, prosecutors argued that this was a premeditated act of revenge, not justice. Years had passed since Brooks had harmed Julia. This was not a heat-of-the-moment decision made in the immediate aftermath of discovering harm. This was calculated retribution that Jay had been planning for some time. The prosecution pointed out that he had acquired the weapon, tracked down Brooks, and chosen a time and place to confront him. These were the actions of someone planning to take a life, not someone acting on sudden impulse. The defense countered with the emotional toll that watching his daughter suffer had taken on Jay. They argued that the passage of time had not healed the wound for Jay or Julia. It had only allowed it to fester and grow deeper. They brought in expert testimony about secondary trauma, about how parents of harmed children often experience their own psychological damage from witnessing their child's suffering. They painted a picture of a father who had been broken by what had happened to his daughter and who saw no other path to peace. Julia herself became a voice in the proceedings and the media coverage that followed. She told reporters that she would kill for her kids too, expressing understanding for what her father had done, while also acknowledging the complexity and pain of the situation. Her statement was both a defense of her father and an acknowledgement that she now had to live with the consequences of his choice. Could a daughter ever truly heal, knowing her father was in prison for her sake? The jury found Jay Maynard guilty of taking Brooke's life. The judge sentenced him to 40 years in prison, a substantial sentence that reflected the premeditated nature of the act. An appeal was filed, but ultimately denied by higher courts. The legal system made it clear. Regardless of the circumstances, regardless of the harm Brooks had caused Julia years earlier, taking a life years after the fact could not be justified under the law. Jay Maynard is currently serving his 40-year sentence in an Alabama prison. Julia has had to cope with not only the original harm she endured, but also the loss of her father to the prison system for what may be the rest of his life. She has become an advocate for others who have survived similar experiences, trying to channel her pain and her father's sacrifice into helping others find paths to healing that do not involve further tragedy. The case underscored a difficult truth that resonates through many of these stories. The desire for retribution does not diminish with time, but the legal consequences for acting on that desire remain severe regardless of how many years have passed. It raised questions about whether there should be any consideration for the ongoing suffering of families, the difference between justice and revenge in the eyes of the law, and whether any amount of suffering can ever justify taking the law into one's own hands after the immediate threat has passed. The next case would involve not just one state, but multiple jurisdictions. Aaron Spencer. In Arkansas, Aaron Spencer was an Army veteran who had served his country with honor. He returned to civilian life and started a family, hoping to build a quiet life after his military service. But his daughter became entangled with Michael Fosler, a man Spencer believed was causing her significant harm and posed a direct threat to her safety and well-being. The details of what transpired between Fosler and Spencer's daughter are not fully public due to ongoing legal proceedings and privacy concerns. But Spencer became convinced that Fosler posed a direct and immediate threat to his family. He felt that the legal system was not moving quickly enough to protect her from further harm. He believed that law enforcement and the courts were failing to take the threat seriously enough. On October 8, 2024, Aaron Spencer confronted Michael Fosler, who was 67 years old, on a rural road in Lonoke County, Arkansas, after finding Fosler in a vehicle with Spencer's minor daughter. According to Spencer's account given to authorities, a physical struggle ensued between the two men. During that struggle, Spencer shot Fosler multiple times. Fosler died from his injuries at the scene. An autopsy was conducted to determine the exact cause and manner of death, though the full results have not been made public pending trial proceedings. Spencer was arrested and charged with homicide. But the circumstances of the case immediately sparked intense debate across Arkansas and beyond. Was this a father protecting his family from an imminent threat? Or was this a premeditated act of revenge disguised as self-defense? The answer to that question would determine everything. Spencer's background as a military veteran became a significant focal point in public discourse. His supporters argued that he was a man who had served his country, a man who understood duty and protection in ways that most people never would. They saw him as someone who had been pushed into an impossible situation by a system that was supposed to protect his daughter, but had failed to do so adequately. They believed he had acted to defend his daughter when the legal system moved too slowly. The prosecution saw it very differently. They argued that regardless of Spencer's military service, regardless of his concerns about Fosler and the threat he may have posed, he had crossed a clear legal line. The law provides specific mechanisms for protection in these situations. Restraining orders exist for this purpose. Law enforcement can intervene when threats are reported. Taking a life is not a legal option except in cases of immediate self-defense where there is no other alternative. But the case took an unusual and controversial turn when Spencer announced his intention to run for sheriff of his county while still facing the homicide charge. This decision raised eyebrows across the state and drew national attention. How could a man facing a serious criminal charge seek election to the position responsible for enforcing the law and maintaining order in the community? His campaign centered on the idea that the current system was fundamentally broken. He argued that the system had failed his family when they needed protection most, and he wanted to be in a position to ensure it did not fail others in similar situations. His supporters rallied behind him with enthusiasm. They saw him as someone who understood the frustrations of ordinary people, dealing with a slow-moving legal system that often seems more concerned with procedure than protection. Would voters elect someone accused of taking the law into their own hands to enforce that same law? Legal complications continued to mount. A judge was removed from the case after the Arkansas Supreme Court intervened, citing concerns about potential bias and impartiality. The removal suggested that the case had become so politically charged that finding an impartial venue was proving difficult. The case became a political lightning rod across the state, with people taking strong positions on both sides. As of January 2026, Aaron Spencer's trial is currently ongoing or nearing its conclusion. He continues to campaign for Lonoke County Sheriff, claiming that his actions were a necessary defense of his child under Arkansas's Stand Your Ground and Justification laws. If you've made it this far and enjoy deep dives into the most shocking criminal cases, hit that subscribe button and don't forget to press the bell icon. While Spencer's case plays out in American courts, some cases involve threats that cross borders and cultures. Fatmir Teralari. In Aigeo, Greece, Teralari faced every parent's nightmare. His daughter had been harmed by someone within the family circle. The perpetrator was his brother-in-law, a man who had been trusted, a man who had access to the family. The betrayal was double: the harm itself and the fact that it came from someone so close. Albanian culture places enormous emphasis on family honor and protection. When harm comes from within the family, it creates a crisis that goes beyond the immediate offense. It threatens the entire family structure and reputation within the community. For Teralari, the situation was intolerable. The details of the specific harm are not fully disclosed in public records due to ongoing legal proceedings and privacy protections for the victim. But the nature of the offense was serious enough that Teralari felt the legal system would not provide adequate justice or protection quickly enough. Teralari confronted his brother-in-law. What happened during that confrontation has been described differently by various sources. According to some reports, there was a physical struggle. According to others, Teralari had decided before the confrontation what he was going to do. The confrontation ended with the brother-in-law deceased. Teralari was arrested and charged with homicide, but the circumstances immediately sparked debate within Albanian society about honor, family, and justice. In traditional Albanian culture, there are deeply rooted concepts about a man's duty to protect his family and respond to violations of family honor. These cultural frameworks do not override the law, but they influence how communities view such cases. The prosecution argued that, regardless of what the brother-in-law had done, Teralari had taken a life outside the bounds of legal self-defense. They emphasized that Albania is a modern state with a functioning legal system. The proper response to such offenses is to report them to authorities and allow the justice system to function. The defense strategy focused on cultural context and extreme emotional disturbance. Teralari's lawyer has revealed what arguments will be made in upcoming trial proceedings. They plan to argue that Teralari acted under circumstances that would cause any father to lose control. They will emphasize the family betrayal aspect and the cultural expectations placed on Albanian fathers to protect their daughters. Could cultural context provide any legal defense? The lawyer has indicated that if the prosecutor's requests are accepted, there may be potential for leniency in sentencing. This suggests that Albanian courts may consider mitigating factors beyond what might be allowed in other legal systems. The cultural weight of family honor and the nature of the brother-in-law's offense may influence the final outcome. The trial proceedings are ongoing. Teralari remains in custody, awaiting the conclusion of his case. Public sentiment in Albania appears mixed. Many, In traditional communities, express sympathy for Terralari's position, while acknowledging that the law must be upheld. Others argue that such cultural considerations should not excuse taking a life. The case has sparked broader discussions in Albania about modernizing cultural attitudes while respecting traditional values. It has also raised questions about how the legal system should handle cases where cultural expectations clash with legal requirements. Women's rights advocates have used the case to highlight the need for better protection systems for victims within families. Legal experts watching the case believe the outcome could influence how future cases of this nature are handled in Albania and potentially other Balkan nations with similar cultural frameworks. The tension between traditional honor codes and modern legal systems remains a significant challenge in the region. Terralari's family has remained largely silent throughout the proceedings. His daughter, the victim of the original offense, has not made public statements. The family appears to be caught between grief over what happened to her and the potential loss of Terralari to the prison system. The final verdict will depend on how Albanian courts weigh the various factors: the premeditated nature of the act, the cultural context, the extreme provocation, and the family betrayal. The case remains unresolved as legal proceedings continue. But not all parents who seek retribution face prosecution. Jason Browning. In Florida, Jason Browning walked in on a scene that would change his life forever. He discovered Raymond Frolander harming his son in their home. The discovery was immediate and visceral. There was no time to think, no time to call authorities, no time to do anything except react. Browning's reaction was physical and immediate. He attacked Frolander with his fists. The beating was severe. Frolander suffered significant injuries from the assault. Medical reports would later document the extent of those injuries, which were substantial enough to require hospital treatment. But here is where this case diverges from the others. Browning called 911 immediately after the beating. He did not flee. He did not try to hide what he had done. He called for help and waited for police to arrive. His 911 call has been widely discussed in legal circles. He told the dispatcher what he had discovered and what he had done in response. Police arrived at the scene, then found Frolander injured but alive. They found Browning waiting. They found evidence of what Frolander had been doing when Browning discovered him. The evidence was clear and undeniable. Browning was initially detained while police investigated. The question facing authorities was whether to charge him with assault. He had clearly beaten another person severely. Frolander's injuries were documented. But the circumstances were extraordinary. Florida law, like most states, allows for the use of reasonable force to protect others from imminent harm. The question became, was Browning's response reasonable given what he had discovered? How much force is a parent allowed to use when discovering someone harming their offspring? After investigation and review by prosecutors, authorities decided not to file charges against Browning. They determined that his actions fell within the bounds of defending his son from ongoing harm. The beating stopped when Frolander was no longer a threat. Browning had not continued the assault beyond that point. He had called for help rather than taking further action. The decision not to charge Browning was met with widespread public support. Many saw it as the correct application of self-defense and defense of others' principles. If a parent cannot use force to stop someone actively harming their offspring, then what is the purpose of such legal protections? Frolander, however, faced the full weight of the law. He was arrested and charged with serious offenses related to what Browning had discovered him doing. The evidence was overwhelming. He ultimately pleaded guilty to avoid trial. He was sentenced to 25 years in prison, a substantial sentence that reflected the severity of his offense. During the sentencing hearing, the judge acknowledged what Browning had done, but noted that the legal system had ultimately functioned as intended. Frolander was being held accountable through the courts, and Browning had acted within legal bounds to protect his son. Browning later gave interviews about what happened. He stated that he had saved his son from further harm by his immediate intervention. He expressed no regret for the beating, but emphasized that he had stopped and called authorities rather than taking further action. His restraint in stopping the assault once the threat was neutralized was key to the decision not to charge him. The case became a reference point in legal discussions about parental protection rights. It demonstrated the difference between taking a life outside the legal system and using force to stop an ongoing threat. The immediacy of the situation, the fact that harm was actively occurring, and Browning's decision to involve authorities rather than continue the assault all factored into the outcome. Browning's son has not been publicly identified to protect his privacy. The family has attempted to move forward from the incident. Browning has become an advocate for awareness and protection, using his experience to help other parents understand warning signs and protective measures. The case stands in stark contrast to others, where parents faced prosecution for their actions. The key difference was timing and response. Browning acted in the moment to stop ongoing harm and then immediately involved the legal system. He did not plan retribution. He did not take a life. He responded to an immediate threat and then allowed the law to take its course. Other parents have channeled their grief into different forms of pursuit. Miriam Rodriguez. In San Fernando, Tamaulipas, Mexico, Miriam Rodriguez became a one-woman detective force. Her daughter Karen had been kidnapped in 2014. The kidnapping was not random. It was part of the epidemic of disappearances that has plagued Mexico for decades, driven by organized criminal groups that profit from ransom and human trafficking. Miriam paid the ransom demanded by the kidnappers. She did everything they asked. She followed every instruction, but Karen was not returned. Later, Miriam would learn the truth. Karen had been taken despite the ransom being paid. The kidnappers had never intended to release her. For many parents, this would have been the end. They would have mourned and tried to move forward. But Miriam Rodriguez made a different choice. She became an investigator. She began tracking down everyone involved in her daughter's kidnapping and death. Miriam used disguises to gather information. She posed as different people to get close to suspects. She gathered intelligence on criminal networks. She learned their routines, their locations, their associates. She became remarkably skilled at investigation, teaching herself techniques that professional investigators use. Over the course of several years, she tracked down 10 individuals she believed were involved in Karen's case. She did not kill them herself. Instead, she gathered enough evidence to lead authorities to them. She essentially did the work that Mexican law enforcement should have been doing, but often cannot or will not do, due to corruption, fear, or resource limitations. In 2016, remains were found in a grave that confirmed Karen's fate. The discovery gave Miriam the tragic closure of knowing what had happened to her daughter, but it did not stop her pursuit of those responsible. Miriam gave interviews about her mission. She stated, "I died when they killed her." Those words captured the depth of her grief and her transformation into someone driven entirely by the need for accountability. She had become a ghost of her former self, existing only to ensure that her daughter's kidnappers faced justice. But her pursuit made her a target. The criminal networks she was exposing and helping to dismantle knew she was a threat to their operations. They knew she would not stop. They knew she would continue identifying and locating them. On Mother's Day, 2017, gunmen shot Miriam 13 times outside her home in San Fernando. She died from her injuries. The attack was clearly intended to silence her and send a message to others who might consider following her path. Her death sparked outrage across Mexico and internationally. She had become a symbol of parents fighting back against the disappearances crisis. She had shown that ordinary people could fight powerful criminal organizations, even if the cost was ultimately her own life. Recent updates show her legacy continues in documentaries about her life and work. Following the 2017 murder of Miriam Rodriguez, Mexican authorities eventually arrested and convicted several individuals connected to the crime. Notably, in 2023 and 2024, judicial updates confirmed that several cartel members involved in the kidnapping of her daughter and the subsequent killing of Miriam are serving lengthy sentences. This reflects the ongoing impunity that characterizes much of the violence in Mexico. Miriam Rodriguez never took a life herself, but her story belongs in this collection because she represents a different form of parental response to loss. She channeled her grief into investigative work that brought down multiple members of criminal organizations. She became what the system could not be: relentless, fearless, and effective. Her story raises questions about what happens when the legal system is so compromised that parents must become investigators themselves. It highlights the difference between revenge and accountability. Miriam sought justice through the courts, but she had to do the groundwork herself because the system would not. Her death also demonstrates the ultimate cost of such pursuits. Taking on criminal organizations, even indirectly through investigation, carries deadly risks. Miriam knew the danger, but continued anyway. She prioritized accountability for her daughter over her own safety. The Miriam Rodriguez case has inspired other parents of disappeared persons in Mexico to become more active in investigating their own cases. It has also put pressure on Mexican authorities to improve their response to kidnappings and disappearances. Her legacy is one of courage and determination, but also of the tragic reality that seeking justice in such circumstances can cost everything. Some fathers choose activism over direct retribution. Eduardo Gallo. In Mexico, Eduardo Gallo faced a nightmare similar to Miriam Rodriguez's. His daughter Paola was kidnapped in 2000. The kidnappers demanded ransom. Gallo, like so many desperate parents, paid what was demanded. He believed paying would bring Paola home safely, but Paola was not returned. Despite the ransom payment, she was taken anyway. The kidnappers had no intention of releasing her. For Gallo, this betrayal compounded the already unbearable loss of his daughter. Unlike some parents who seek direct retribution, Gallo chose a different path. He spent 11 months tracking the gang responsible for Paola's kidnapping and death. He worked methodically, gathering information, following leads, building a case. He essentially conducted his own investigation parallel to what authorities were doing. His tracking efforts led to confessions from gang members. The evidence he helped compile contributed to prosecutions. Multiple individuals connected to the kidnapping were arrested and convicted. Gallo had succeeded in bringing legal accountability to those responsible. But he did not stop there. Gallo made a conscious decision about how to channel his grief. He told reporters, "Justice, not revenge," when describing his mission. Those 3 words became his guiding principle. He wanted the system to work, not to circumvent it through vigilante action. Gallo became an anti-kidnapping activist. He used his experience and the knowledge he had gained during his investigation to help other families facing similar situations. He worked to raise awareness about the kidnapping crisis in Mexico. He pushed for better law enforcement response and better protections for potential victims. His activism took various forms. He gave speeches, he worked with advocacy groups, he consulted with other families whose loved ones had been kidnapped. He became a voice for systemic change rather than individual retribution. Recent updates indicate Gallo continues to live in Mexico and remains active in anti-kidnapping advocacy. He has not faced legal consequences for his investigative work because he worked within the system rather than outside it. He gathered evidence and provided it to authorities rather than taking direct action himself. The Eduardo Gallo case presents a stark contrast to others in this collection. He had every reason to seek personal revenge. He had lost his daughter despite paying ransom. He had spent nearly a year tracking down those responsible. He knew where they were and what they had done, yet he chose to pursue justice through legal channels. His choice raises important questions about grief and response. What makes some parents choose the legal path while others take matters into their own hands? Is it temperament? Is it faith in the system? Is it calculation about outcomes? Gallo clearly had the determination and skills to have pursued direct retribution if he had chosen that path. But he deliberately did not. His activism has had lasting impact. He has helped numerous families navigate the kidnapping crisis. He has contributed to policy discussions about how to combat kidnapping in Mexico. He has shown that there is another way to respond to unspeakable loss. The contrast between Gallo and Rodriguez is instructive. Both pursued those responsible for their daughters' deaths. Both spent considerable time and effort investigating. But their approaches and outcomes differed significantly. Rodriguez's pursuit led to her own death at the hands of the criminals she was exposing. Gallo's approach allowed him to continue his work and help others. Whether one path is better than the other is not for outside observers to judge. Both parents acted out of profound love for their daughters and profound grief at their loss. Both sought accountability in a system that often fails to provide it. Their different choices reflect different personalities, circumstances, and perhaps different levels of faith in the possibility of systemic justice. The final case brings us full circle to American streets. Bokio Johnson. In New Orleans, Louisiana, Bokio Johnson was an electrician living an ordinary life. He had children, Caleb and Brianna. In 2021, both of his children were taken by Hollis Carter. The details of how Carter took them have not been fully disclosed in public records, but the loss of both children devastated Johnson completely. Carter was arrested and prosecuted for taking the lives of Johnson's children. He was convicted and sentenced. The legal system had functioned. Justice had been served in the technical sense. Carter would spend the rest of his life in prison. But for Bokio Johnson, that was not enough. Johnson spent months planning. He tracked Carter's location within the prison system. He waited for an opportunity. In March 2022, Johnson made his move. He shot Carter, ending his life. The details of how Johnson accessed Carter are not fully public, but ballistics later matched the weapon to the scene. Johnson was arrested and charged with homicide. The prosecution argued that this was premeditated revenge. Carter had already been convicted and imprisoned. The legal system had worked. Johnson had taken the law into his own hands, not to stop an ongoing threat, but to exact personal retribution against someone already serving a life sentence. The defense argued that no sentence could provide peace to a father who had lost both children. They emphasized the impossibility of moving forward, knowing that the person who had taken both Caleb and Brianna was still breathing, still existing, even if behind bars. They painted Johnson as a man broken beyond repair by his loss. The jury was not swayed by the defense arguments. They found Johnson guilty of taking Carter's life. The verdict reflected the legal principle that regardless of circumstances, regardless of what Carter had done, taking a life outside of legal execution or immediate self-defense is homicide. Bokio Johnson was sentenced to 40 years in prison in May 2024 for the second-degree murder of Hollis Carter. The sentence was substantial, reflecting the premeditated nature of the act. At sentencing, Johnson's remaining family members were present. They expressed relief that Carter was gone, but acknowledged that a void remains in their lives. Carter's removal had not brought back Caleb and Brianna. Now they had also lost Bokio to the prison system. The family's statement captured the fundamental tragedy of these cases. Taking revenge does not restore what was lost. It only adds more loss. Johnson's remaining family now grieves not only for Caleb and Brianna, but also for Bokio, who will spend the next 3 decades behind bars. An appeal is reportedly possible, though details have not been widely reported. Legal experts watching the case believe an appeal is unlikely to succeed, given the clear premeditation and the fact that Carter was already imprisoned when Johnson acted. Social media debates about the case have been intense. Many people express sympathy for Johnson and question whether he should have been prosecuted at all. Others argue that allowing such acts would undermine the entire legal system. The online discussions reflect broader societal questions about justice, revenge, and the limits of parental grief. The Bokio Johnson case is particularly tragic because Carter had already been convicted and imprisoned. Unlike cases where parents act because they believe the system has failed, Johnson acted after the system had successfully prosecuted and imprisoned his children's killer. His act was purely about personal closure, not about achieving justice that the courts could not provide. This raises questions about what drives such decisions. Is it about justice or about the need to personally inflict consequences? Johnson could have taken some comfort in knowing Carter would die in prison. Instead, he chose to ensure Carter's death came sooner and by his own hand. That choice cost him 30 years of freedom. The case also highlights the ripple effects of these acts. Johnson's remaining family members now face decades without him. They have lost 3 family members, the 2 children to Carter, and now Bokio to the prison system. The void the family described is not filled by Carter's death. If anything, it has grown deeper. This was all from our side today. Thanks for watching. Click here to check out another video.